All rise, you're entering the courtroom.
You may be seated. Jury is present in the courtroom. State, you may proceed.
Thank you, Your Honor. And before I start, just for the record, we were at 1 minute and 16 seconds when the video cut out. Officer, so we're going to start with watching the video in the backseat of your cars again.
Okay.
Officer Niles. The Senate tow truck needs the actual car. Seven five one seven and still have his keys. Ten 40 minus on the recording. He says he wants them all. He doesn't care. He says they're going Yeah. Yeah. Okay. You want this to go with you? All of your keys? Okay, your car is all done. So you're going to jail for DUI. Well, you're going to jail for DUI. Camera's been rolling the whole time. I did not. I told you I did not.
bullshit. So on y'all do the shit. Now, let's go. Let's go time, do whatever. Fuck this shit,
record, the state stopped at 11 minutes and 11 seconds. Officer, I know we just listened to quite a bit of information from the defendant in the backseat of the vehicle. Do you recall if he mentioned going to the club again?
I believe he said something to the effect of, you're arresting me because I said I had a couple drinks. You can't do that.
And to be clear, did you arrest him for being under the influence of alcohol or for marijuana?
Under the influence of alcohol.
Okay. So when you were talking with him throughout the entire course of your investigation, you specifically, did you ever tell him that he was under arrest because of marijuana?
No.
Okay. Now, as we've already talked about, so you initially encountered the defendant in his vehicle?
Yes.
Okay. The individual who was driving that vehicle, do you see him in this courtroom here today?
Yes.
Could you point to him and identify him by an article of clothing?
The gentleman seated over there wearing the brown jacket.
The state has no further questions.
Cross-examination?
Yes, Your Honor, if we could have a 5-minute recess for technology.
Okay. It's 10:25, ladies and gentlemen. We'll resume at 10:30. Please don't discuss anything you've heard so far, and do not look up anything related to the case. If you need your technical person to come back up, you can.
I think it should be good. It's downloading right now, so
Okay.
just a few more minutes.
Okay, let's bring the jurors back in.
No, Your Honor, I'm sorry, we have an issue to address with the court.
Okay, hold on.
Ms. Goodell just informed me she's not playing the video from the disc itself that's been entered in evidence. She's instead playing downloaded videos. We would ask that she play it straight to the disc that was entered into evidence.
Your Honor, I downloaded it directly on it. It's just going to run smoother from my computer, but if you're okay with, sometimes it might just take a bit longer to pull up with the disc, but if you're okay with that, then
I would prefer it to be played directly from the piece of evidence.
Okay.
And I apologize for the interruption, Your Honor.
Which disc is it?
Your Honor, I believe that is State's Exhibit 4.
States 4, yep. Okay, let's bring him in.
All rise, jury entering the courtroom.
You may be seated. Spence, you may proceed. Jury is present in the courtroom.
Officer Muth. In Florida, it is not against the law to drink alcohol, then drive. Is that right?
If you drink alcohol to the point that you're impaired, it's illegal.
But it is only a crime if the person drinks alcohol to the extent that their normal faculties are impaired.
Correct.
So it's not illegal for somebody to have drinks, be fine, and then drive.
If they're not impaired, correct.
You were Officer Oliver's backup,
At first, yes.
and you responded to where she was with Mr. Riley.
Yes.
You never saw Mr. Riley swerving in the road.
No.
That's all based on Officer Oliver's word.
Correct.
It was Officer Oliver who called you to the scene.
Yes.
She told you that she observed some DUI indicators.
Yes.
In fact, she indicated that she wasn't 100% sure.
Yes, that's why she called me.
Specifically, she tells you that she can't really smell anything.
Yes.
She wants you to go see if there's more.
Yes.
At that point, you walk to Mr. Riley's car.
Yes.
You talk with him.
Yes.
Then you go back to talk with Oliver.
Yes.
You decide, at that point, you ask Officer Oliver if she wants you to do a Signal 1 investigation.
Yes.
And she asks if she can ring watch.
Yes.
She giggles and tells you that she promises she'll do the next one.
Yes.
She told you that Mr. Riley's driver's license is suspended.
Yes.
In fact, she tells you that he knows it's suspended.
Yes.
She tells you that's why he didn't have it on him.
I can't recall if she said that.
Would you like to see your body-worn camera?
Okay.
Officer Muth, just to clarify, at the beginning of your video, you arrive on scene, but there's no sound, correct?
Correct.
But Officer Oliver had a body-worn camera on,
Yes.
and so she would have picked up that conversation.
Yes. All right, you may proceed.
That's why he doesn't have the driver's license, because he knows it's suspended. So.
Now that you've been able to watch Officer Oliver's body-worn camera, she tells you that's why he didn't have it with him.
Yes.
And she told you this more than once.
I haven't reviewed Officer Oliver's body-worn camera. I don't know if she told me more than one time.
Would you know if you saw Officer Oliver's camera?
Her camera would have captured things in the beginning because my camera doesn't capture the sound when I first arrive on scene. So if she said it again, hers would have captured it and mine wouldn't have.
So are you denying that she told you multiple times?
No. I'm just saying I don't recall if she told me multiple times.
Would you remember if you saw a body-worn camera?
Yes.
Can I watch you? I promise not to help it. Go ahead, sir. Exit system
And so Officer Oliver told you a second time before you approached Mr. Riley that he knew his license was suspended.
Yes.
At that point, you and her go to Mr. Riley's car together.
Yes.
He was cooperative with you when he shut off his car.
Yes.
He was cooperative with you when he put his car keys on the dashboard.
Yes.
You approached him on the driver's side.
Yes.
You then ordered Mr. Riley out of the vehicle.
Yes.
He complied.
Yes.
Officer Oliver placed Mr. Riley in handcuffs.
Yes.
You placed him under arrest for driving while license suspended.
And DUI.
And that's your testimony here today.
Yes.
That you arrested him for, at that time, when he was placed in handcuffs, for driving while license suspended and DUI.
Yes.
Were you wearing a body-worn camera?
Yes.
Yeah, okay. Ladies and gentlemen, there's some things we have to do outside of your presence, so please, if you could just go back to the jury room, please do not discuss anything you've heard so far, and please leave your notes on your chairs. It should be a short break for you, so just please, if you need to use the restroom or anything, do it quickly, because we will be able to bring you back fairly shortly. Yeah, please leave your notes. Thank you. You may be seated. Jury is not present in the courtroom. Ms. Goodfellow, you may proceed.
Officer Oliver, it's your testimony here today that you arrested Mr. Riley at that point when he was placed in handcuffs for driving while license suspended and DUI.
I'm Officer Muth, not Officer Oliver.
My apologies, Officer Oliver. Officer Muth, that's your testimony here today, correct?
Yes.
And both you and Officer Oliver were wearing body worn cameras.
Yes.
License is suspended, so we're gonna.
No problem. Oh, should I call somebody?
Your Honor, if I may, based on the court's previous ruling and the rule of completeness, we believe that Ms. Goodfellow needs to play the portion before he was placed under arrest too that was previously suppressed, because it does go into why she arrested him. And the defense is currently suggesting that he was only placed under arrest for driving with a suspended license, but that's simply not true. He was asked to do field sobriety exercises, and then he was placed under arrest after he refused, so that goes directly into why he was arrested, and we request that it's fully played.
Well, at this point, you haven't even asked her a question. You're just playing the video. So if you want to do that and state if you want to come back in your redirect, then we can.
Your Honor, just for clarification, are you saying that we're allowed to discuss that?
We'll have to
issue
do
now?
that outside of the presence of the jury, but if you want to talk about it, to refresh your recollection and then ask her a question, we can do that with the jury present after you've refreshed your recollection with the video.
Your Honor, based on the situation, the state does not have a unredacted version of that. We would ask if we could use the defense's unredacted version that we are on.
For brevity, can you just back it up a little bit and let her hear the whole interaction, please? The jury's not present.
Yes, Your Honor. What the record books is, you're ordering me to go backwards, but that doesn't supersede your previous order, so it's not opening the door, correct?
Correct.
License is suspended, so we're gonna.
No problem.
You need to go back to when he was in the car and she talked to him.
Is that what's correct, Your Honor?
I believe so. I don't know what's being said right now.
Your Honor, if the state would ask for 10 seconds the skip back, I believe there might be a little bit more. I'm just not sure.
Do you know what the time frame, the time stamp is?
I don't. I just know it's immediately upon the approaching the car, so I can't tell based on this time frame whether or not that's immediately when they first approached.
All right, if you can just go back to when she approaches the car and bends down.
I believe this is when she's leaving,
Okay.
and this is from Officer Oliver's body worn camera, because that's the unredacted version that I have.
Okay.
Would you be willing to do some voluntary exercises? No? Okay, here, go ahead and sit by the vehicle for us. The car for us, your license is suspended, so we're gonna.
No problem.
Would you like to see more?
That's all you want to play for, that's fine.
Would you like me to ask her now and then she can reiterate the answer?
We'll
for the
proffer
jury?
it now, and then we can go back and ask it in front of the jury.
Officer Muth, now that you've watched your body, or Officer Oliver's body-worn camera of that interaction,
Yes.
isn't it right that you only told him he was arrested for a driving while license
Objection
suspended
is
or revoked?
characterization of the evidence.
She can answer the question.
Sure, I said that. I'm not required to list out all of the charges he's under arrest for, and he had just refused the field sobriety exercises, so I thought he would infer that he was also under arrest for DUI in addition to the DWLSR.
Your Honor, would you like me to continue with the proffer?
Nope, let's bring the jury back in, and you can re-ask the question.
Your Honor, if I may, just before we continue, just putting on the record that the state believes this opens the door as to the reason for the arrest.
Well, she can ask the question, and whatever answer she gets, she has to live with, so.
I'm just putting that on the record.
She
so
just heard
counsel's
the answer to
aware.
the question. If she wants to ask it again, then we'll see where we go.
All rise to re-entering the courtroom.
Officer Muth, now that you've just had a chance to watch Officer Oliver's body-worn camera of the interaction you had with Mr. Riley, isn't it true that you only informed him that he was arrested for driving while license suspended and not DUI?
Sure, I said he was under arrest for driving while license suspended. However, he had just refused the field sobriety exercises when I asked him to step out of the vehicle, so I thought he would infer that he was also under arrest for DUI. We're not required to list out all of the defendant's charges when they're placed under arrest.
May I have 1 moment to confer, Your Honor? I want to talk to you about the search of Mr. Riley's car. You searched this car with Officer Oliver.
Correct.
The first thing you notice is the air freshener.
Yes, it was like he had sprayed cologne or air freshener.
And Officer Oliver indicated that it was a very strong odor.
Yes,
And you did find cologne in his car.
yes. I believe there was a bottle.
But, and like you said, you assumed he must have sprayed it right before.
I don't know if I said that or if Officer Oliver said that.
But it was an assumption raised.
Yes.
But you have no evidence of that happening in this case.
No.
As you're searching on the passenger side, you indicate that you now have enough for a Signal 1 investigation.
I said if she wanted to keep searching the car, I'll go ask him the Signal 1 questions.
But you didn't indicate that you now had enough for a Signal 1 investigation.
I don't believe I did, no.
And that's your testimony here today.
Yes.
And you had a body-worn camera on.
Yes.
After what you said was smelling alcohol, you then said, yep, that's enough for a signal 1.
I couldn't hear if that was what I said.
Do you need to hear it again?
Yes.
Officer Muth, it was right at the beginning of that video. Did you hear it that time?
I'm sorry. No, I can't hear what I'm saying.
But it's then that you believe you can fully conduct a DUI investigation.
Well, he was already under arrest for DUI.
In fact, you laugh about that being based on your training and experience.
I laughed at the smelling alcohol based on my training and experience.
And you think it's funny.
It was a mistake. We answer calls for service all day. We have to find humor where we can.
I want to talk to you about the bottle of vodka. Officer Oliver found the bottle in a pouch by the driver's side floorboard.
I believe she said it was in a pocket on the driver's seat. I never saw where she produced the bottle from.
You were not present when she found the bottle?
I was in the vehicle, also searching the passenger side. I did not see where she got the bottle from.
But you automatically assumed that that's what was in the Tervis mug.
Yes.
And you did use the vodka bottle as evidence.
Like how I stated previously, we found it in the vehicle, so I listed it in my report because I didn't want to look like I was hiding anything.
But you used it as evidence.
The vodka bottle?
Yes.
No.
That's your testimony here today, that you did not use the vodka bottle as evidence.
Correct.
You've testified previously at a pretrial hearing, correct?
Yes.
And at that hearing, you were under oath.
Yes.
You swore to tell the truth.
Yes.
Your Honor, may I approach her with your deposition?
Yes.
For court and counsel, that is page 40 of her pretrial hearing transcript. Page 40, line 27 through 28, continues on to page 41, lines 1 through 3.
Your Honor, the state would ask to see a copy of this.
I would like to have a copy too.
Your Honor, we were all present there. Do I still need to bring additional copies?
A pretrial order, it says if you're going to impeach anyone with their prior statements, you need to provide copies to everyone, including the court. Do
Then,
you
Your
have
Honor,
copies?
may we have a 5-minute recess so I can print off copies for everyone?
Yes, we'll take a 5-minute recess. Ladies and gentlemen, please don't discuss anything you've heard so far. Please leave your notes on your chairs.
Yeah, the only copies I have are the top line, so there's 50 of that in there, but- So it starts on page 40, line 100 to 28, and continues on to page 41, line 103. That he used the bottle as evidence.
And evidence in general or evidence in
Evidence.
Okay. Okay. Well, doesn't actually. give enough time.
Back on the record, state your Riley, defendant is present at council table. Looks like I've got a copy. State, you have a copy of the
Yes, Your Honor.
deposition or the pretrial hearing?
Yes, Your Honor.
You ready to proceed?
Yes, Your Honor.
No, Your Honor, we would object to improper impeachment and asked and answered.
So we'll get to that when she starts asking her questions. You may be seated. I mean, until the jury comes in. Let's bring the jurors in.
All rise, you're entering the courtroom.
You may be seated. Jury is present in the courtroom. Ms. Goodfellow, you may proceed.
Officer Muth, is your testimony here today that you did not use the vodka bottle as evidence?
Are you asking if I used it as evidence to arrest him?
I am asking you if you used it as evidence.
It was discovery after he was already placed under arrest.
Officer Muth, you testified previously at a pretrial
Objection to
hearing.
improper impeachment.
She's got to get her information out. Overruled at this time.
You testified previously at a pretrial hearing.
Yes.
You were under oath at that hearing.
Yes.
You swore to tell the truth.
Yes.
There you were asked in counsel in court. It's page 40, lines 27 through 28, continuing on to page 41, lines 1 through 3. Question. And in that report, you mentioned that a vodka bottle was found in a pouch on the driver's seat. Is that correct? Answer. Correct. Question. And you mentioned that because it was evidence. Answer. Yes. That's inconsistent with your testimony today.
Okay. You asked me about the vodka bottle, and I thought you meant it played into his evidence in his arrest. At the point the vodka bottle was found.
But you had automatically assumed that that vodka bottle was what was used and put in that cup.
Yes, which was a mistake on my end.
And you thought that even though the bottle was sealed and had never been opened.
I never examined it.
And again, you confirmed that he's only under arrest for driving while license suspended.
That's what I told him. I thought he would infer that he was also under arrest for DUI because he had just refused the field sobriety exercises.
At that point, you were only charging him with driving while license suspended.
No, he was placed under arrest for DW, LSR, and DUI.
That's your testimony here today.
Yes.
You had a body-worn camera on.
Objection asked and answered.
Sustained. We've been through this.
No, Your Honor, it's a different point in time.
Okay, go for it. Overruled.
Your Honor, can we just briefly move sidebar?
Not yet. Let her finish her questions. to see if there's another
Your Honor,
objection.
the state was just curious as to whether or not this is the one that was entered into evidence or if it was the other one.
Yeah, if you could use the video from Exhibit 4. Okay.
If you wanted to, if you wanted to start telling me if you wanted to finish searching all the.
At that point, you were only charging him with driving with license suspended.
No, he was under arrest for DUI and DWLSR.
That was not my question. At that time, you were only charging him.
Asked and answered.
Sustained, she just said he was under arrest for DUI and DWLSR.
Those are not the same thing, Your Honor.
Let's go sidebar so you can explain it to me.
So when you walk away from Mr. Riley's car, you're done searching the car at that point.
Yes.
Officer Oliver, though, continues to search the car.
Yes.
You go back to speak with Mr. Riley.
Yes.
He's upset that you claim to smell marijuana.
I never smelled marijuana. Officer Oliver did.
He's upset that Officer Oliver said that she smelled marijuana.
Yes.
But you never smelled marijuana.
Correct.
You never found any evidence of marijuana.
Correct.
You described him as extremely irate and belligerent.
Yes.
You indicate in your report that he attempted to exit your car.
While I was reading implied consent. Yes.
He never moves his feet.
He leaned forward towards me.
He leans into your body-worn camera.
He leans his body towards my body. I don't know what he's going to do.
He wasn't trying to escape.
I can't speak to that.
Again, at this point, you have only told him that he is under arrest for driving while license suspended. And then Sergeant Smith comes on the scene. There's a point where you're discussing what to do with his car.
Yes.
Officer Oliver suggests moving it to the parking lot,
Yes.
but you disagree.
Yes, I said we should tow it.
And you want to tow it because to you, he'd done nothing to meet you all in the middle.
Yes, that's what I said.
When Sergeant Smith is there, you discuss the search.
Yes.
And when he first asks you if there's anything in there, you indicate no.
I thought he had meant the marijuana.
Then you say, well, okay, so he had a bunch of alcohol stashed in there.
Yes.
He specifically asks you nothing open or anything.
Yes.
And you say, yes, it was opened.
Yes.
That there was a mixed drink in the center console.
Yes.
You're explaining to Sergeant Smith that he was mad, and then Mr. Riley was mad that Officer Oliver smelt marijuana.
Yes.
That is why you searched the car.
We searched the car for her plain smell of marijuana and then the search for the DUI.
Sergeant Smith asks if you're still alive.
I can't speak to what Sergeant Smith said. I believe he said he was still alive.
And that means that your body camera is still on.
Yes.
Specifically, he asks you, did you find any evidence of marijuana?
Yes.
And you say no.
Yes.
And this is when Officer Oliver walks up.
Yes.
She asks you if you got all the same indicators she did.
Yes.
You are still discussing this arrest.
Yes.
You are still discussing this case.
Yes.
You are still investigating.
We're discussing.
And then you turn off your body-worn camera.
Yes.
But first you ask her if she still got her body-worn camera on.
Yes.
And she shakes her head no.
I believe she did.
And then yours cuts off and your next body-worn camera turns back on 3 minutes later.
Yes.
There are 3 minutes at this exact same time where you all have your body-worn cameras off.
Yes.
The first time you tell him he's going to jail for DUI is when he's already in the car on his way to jail.
Yes.
And that's after you search the car.
Yes.
A moment to confer, Your Honor.
Yes.
Nothing further, Your Honor.
Any redirect?
Briefly, Your Honor. Officer, I want to start from the beginning of where Ms. Goodfellow asked you questions about. Why were you called to the scene?
To investigate a DUI.
Okay. Was that because you were helping Officer Oliver?
So she had been on the squad for a little bit and she wanted to learn how to do DUIs. So I was helping teach her.
So we talked about, or Ms. Goodfellow talked about a Signal 1 investigation. Can you tell the jury a little bit about what a Signal 1 investigation is?
Signal 1 is just our code for DUI investigation.
So does a Signal 1 or DUI investigation, does that start from the moment you make contact with the individual?
Yes.
Does it extend all the way until the very end of the investigation?
Yes.
So when you were conducting a search of the vehicle, were you still in a Signal 1 investigation?
Yes.
What about when you're reading implied consent?
Yes.
Okay. What about when you asked the defendant to do field sobriety exercises?
Yes.
Now, we also talked about field sobriety exercise. I believe Ms. Goodfellow actually brought up the fact that there was field sobriety exercises request. Can you tell the jury what the defendant did when he was asked to do field sobriety exercises?
Sidebar.
Your objection is sustained. Move on.
Defense counsel also asked you about how Officer Oliver said she knew that the defendant knew he had a driver's license suspension. Did Officer Oliver tell you about the notices that were sent to his P.O. box?
I believe she said they were sent to the Brevard Street address box.
But did she tell you that there was notices sent?
Yes.
Can you explain to the jury what notices when notices are sent, what that means for an investigation for somebody who's driving with a suspended license?
They sent.
Objection, call for hearsay in Crawford.
Overruled.
I'll ask the question again. Can you just tell the jury a little bit about when notices are sent to an individual from the DHSMB?
Objection, beyond scope.
Overruled.
Officer, can you please tell the jury when notices are sent to an individual and DHSMB tells you about that in the internal system, what does that mean for your investigation for somebody who's driving with a suspended license?
DHSMV will send the suspension notice to their primary residence, and in this case, they sent the suspension notice to his primary residence, and it updates in our system with the address that the notice would have been sent to.
Your Honor, permission to publish State's Exhibit 1, what's already been entered?
Yes.
Also, let me know when you can see it.
Okay, I can see it.
Now, I'm directing your attention to right here where it says, right up here in the corner. Can you tell us where this document's from?
It looks like the Florida DHSMV.
Now I'm directing your attention to the subheader that says mailing address. Can you tell the members of the jury the mailing address for the defendant?
You want me to read the address?
Yes, please.
P.O. Box 11184, Tallahassee, Florida 32302.
Officer, if that was the address listed if that was the defendant's mailing address listed with the DHSMV, would that have been where his notices were sent?
Objection, beyond scope.
Sustained.
Now I want to transition over into another section of questioning that the defense asked you about. When you placed the defendant under arrest for DUI, did you believe you had probable cause to arrest him for DUI?
Yes.
Did you believe you had probable cause to arrest him for driving with a suspended license?
Yes.
Let's take those one by one. When you arrested him for DUI, can you tell the jury why you believed you had probable cause at that point?
Objection, Your Honor, cumulative.
Overruled.
Can you tell the jury why you believed you had probable cause to arrest him for DUI at that point?
Based on the totality of the circumstances, Officer Oliver had observed poor driving patterns, and then my own personal observations with the thick, slurred speech, watery, bloodshot eyes. He had said he was leaving a bar and said that he had consumed a couple of 2 beers there.
Now I want to transition into the second charge. Can you tell the jury why you believed you had probable cause for the driving with a suspended license?
The suspension notice had been sent to his primary residence.
Officer, after you placed the defendant under arrest, did you also search his vehicle?
Yes.
Okay. So, can you explain to the jury, when you search somebody's vehicle, or are you allowed to search somebody's vehicle automatically when you place them under arrest?
No, there has to be, it depends on what they're under arrest for, and there has to be certain things.
Typically in DUI investigations, are you able to?
Yes.
Okay. When you decided to search the vehicle, did it have anything to do with the smell of marijuana?
We could search on Officer Oliver's observation of the plain smell of marijuana, and but we could also search for the DUI.
In DUI investigations, actually strike that. I want to be clear, was marijuana what you suspected the defendant to be under the influence of?
No.
Can you tell the jury what you suspected him to be under the influence of?
Alcohol?
Was alcohol your primary concern throughout your investigation?
Yes.
Now I want to transition also to the breath test that you asked from the defendant. Opposing counsel asked you a bit about how the defendant was leaning towards you. Can you describe to the jury what it was like when he was leaning towards you as you read the implied consent form?
Objection, relevance.
Overruled.
Can you tell the jury what it was like as he leaned towards you when you read the implied consent form?
Sure. So I was just trying to read the implied consent form. Like I said, it was one of those procedural things for a DUI, and he was yelling at me the whole time, and then when he was leaning towards me, I didn't know what his intentions were. So that's why I shut the door, and then I continued reading implied consent through the open window. I thought he might, if I had kept the door open, I thought he might try to exit the vehicle or try to, I guess,
Objection calls for speculation.
Sustained.
Officer, can you just give us a visual estimate with your hands about how far away he got to you, or how close he was to you when he leaned towards you?
I would say probably that close.
No further questions.
Does this witness need to be retained?
Yes, Your Honor.
All right, you can step down, but please do not leave the courthouse.
Thank you. I still have the paperwork that.
You can retrieve it. Yes. State, you may call your next witness.
The state calls Sergeant Smith to the stand. And if I could just have a moment to clear the box.
You could stop right there and let the clerk swear you in, please.
You solemnly swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
All right, you may have a seat. State, you may inquire.
Thank you, Your Honor. Could you please introduce yourself to the members of our jury?
Yes, my name is Brian Smith. I'm a sergeant with the City of Tallahassee Police Department.
And for the record purposes, can you spell your last name?
Yes, it's S-M-I-T-H.
Sergeant Smith, I want to talk about your experience as an officer for starters.
Yes, ma'am.
Could you tell us, I know you said you work for the Tallahassee Police Department. When did you start working for them?
In December of 2008.
Okay. So for a total of how many years at this point?
It's 15.
So during the 15 years at Tallahassee Police Department, did you receive any training related to DUI investigations?
I did not specifically, no, ma'am.
Okay. Have you ever responded to DUI investigations?
Yes, ma'am.
Are you usually backup, or can you give us a little insight into what your involvement usually is?
Typically, it's as a backup officer, so it would just be for, while the officer is conducting their investigation, I would just be there for safety purposes, or to assist with traffic control, just depending on the situation.
Okay. So I want to transition over to this case.
Yes, ma'am.
Do you recall if you were on duty the early hours of May 7th, 2023?
Yes, I was.
Were you called to a scene of a traffic stop around 2 a.m.?
Yes, ma'am, I was.
Can you tell us what your understanding of your involvement was that morning?
Initially, they just asked for me to respond. When I got there, I was informed that Mr. Riley had been combative, and they just needed assistance getting him from Officer Oliver's vehicle to Officer Mule's vehicle.
Do you recall what time you arrived at?
It was right around 2:25, 2:26-ish in the morning.
So when you arrived at the scene, did you end up speaking with the defendant at all?
Yes, ma'am, I did.
Did you have your body-worn camera footage on?
Yes, ma'am, I did.
If I showed you a copy of that, would you recognize it?
Yes, ma'am.
Permission to approach?
Yes.
Let the record reflect from showing opposing counsel was been pre-marked as State's Exhibit G. And I am now approaching the witness for the second.
Sergeant, I've just handed you what's pre-marked as State's Exhibit G. Can you tell us what that is?
It's a CD
And-
with my signature on it.
What's on this CD, to your knowledge?
It's actually my body-worn camera from the night of the incident.
Did you have an opportunity to review that before today?
Yes, ma'am, I did.
Were you able to confirm if this was a fair and accurate copy of your body camera?
Yes, ma'am, it is.
Has it been changed or altered in any way since you last seen it?
No, ma'am.
The state moves into evidence what's been pre-marked as State's Exhibit G as State's Exhibit 6.
Any objection?
We would object and ask to approach on one brief testimony.
Sorry, ladies and gentlemen, we need to take another break. This is going to be a very short one. I just need to listen to something and rule on it outside of your presence. If you can please leave your notes on the chair and do not do any research or look up anything related to the case. You may be seated. Okay. State, if you can just proffer, we believe that the statement is in the first minute of the disc.
Judge, I believe it's exactly at 1 minute,
At
so
1
a
minute.
couple seconds before it, and I think it goes for about 5 seconds. It was my memory from this morning.
Okay.
sorry, Your Honor, it's just loading real quick.
No problem. Okay.
This video is cumulative. I understand that you want to get a better hearing of what he said, but we've seen, I think, 2 different videos of his interactions with Sergeant Smith. So I think that this video is cumulative, unless you have an edited copy that you can proceed with right now.
Your Honor, I can actually just address it with him without the video.
Okay.
Your Honor, if I may, we tend, if they're planning on, we're not objecting to the introduction of the video, I think that portion can be muted. We intend to play the video to show him maneuvering his hands, which isn't captured in the other 2 angles.
The problem with them muting it is that that disc is in evidence, and so whatever's on it's in evidence.
That's a good point. Perhaps we could continue, have it muted while they're here, and then have them make a copy so that way everyone's waiting on the redaction. Is one idea. I'll defer to the court.
Are you fine with, I mean, as long as the defense is okay with that, I'm okay.
We're okay to just mute it.
The state won't, but it's
Okay. All right, so let's bring the jurors back in.
All right, turn into the courtroom.
You may be seated. State, you may proceed.
Thank you, Your Honor. Sergeant, when you arrived to the scene, did you talk with the defendant about breath test?
Yes, ma'am, I did.
Could you just explain to the jury what your interaction was relating to the breath test that you were asking about?
Sure. Mr. Riley was upset about the whole situation, so I just explained to him that he'd be afforded the opportunity to provide a breath sample if all this was a misunderstanding.
So when you say to the defendant, if this is all just a misunderstanding, to take a breath test, can you tell the jury how he reacts and responds?
From my interpretation, he was not interested in that avenue.
Would you classify it as a refusal?
It wasn't explicitly stated, but in my opinion, he was refusing.
No further questions.
Cross-examination?
Yes, Judge. Good morning.
Good morning.
So you showed up after the fact,
Yes, sir.
kind of there to keep everything level-headed.
Yes, sir, to move him from one vehicle to the other.
And so by the time you showed up, he had already been arrested.
Yes, sir, he had.
And he was in Officer Oliver's car when you arrived,
Yes, sir, he was.
and he was subsequently transferred to Officer Muth's car.
Correct. Yes, sir.
He was cooperative when you transferred him.
Yes, sir.
He was able to walk on his own to the car,
Yes, sir.
didn't trip.
I don't
Objection
recall.
outside the scope.
Overruled.
He didn't fall,
No, sir, he did not.
he didn't stumble.
No, sir.
He was able to get in the vehicle with no issues.
Yes, sir.
You helped Mr. Riley make a call after that point,
Yes, sir, I did.
while he was in the vehicle.
Yes, sir.
Objection outside the scope.
Overruled.
He was able to call someone and explain what was happening.
Yes, sir.
And he was cooperative while you were helping him do that.
Yes, sir, he was.
His hands were cuffed behind his back.
Yes, sir.
He's seated.
Yes, sir, he's seated.
He maneuvers his handcuffs kind of over to the side,
Yes, sir.
opens his phone,
Yes, sir.
and then types the numbers,
Correct. Yes,
calls
sir.
his family. And he was cooperative with you up until Officer Muth and Officer Oliver returns.
Yes, sir, he was.
Okay. And after that point, he declined any further communication.
Correct. He did not want to speak.
Okay. He stated several times he was not talking to you guys.
Yes, sir.
And after ending the conversation with Mr. Riley, you spoke with Officer Muth about the search of Mr. Riley's car.
Yes, sir, I did.
You asked her if she found anything.
Yes, sir.
She says she had a bunch of alcohol stashed in there.
Objection outside the scope.
Overruled.
Yes, sir.
So, she did say she had a bunch of alcohol stashed in there, correct?
Yes, sir, she did.
And you, when you're the supervising officer, take the officer's word on that.
Yes, sir.
You didn't do any, you didn't check for yourself to see if it was open or half poured out or anything like that.
I did not check, sir. No, sir.
You kind of rely on them being truthful with you.
Yes, sir.
And then you guys ended up discussing with Officer Oliver the evidence that you believe supported a DUI charge.
They may have gone over some things, yes, sir. I don't recall exactly what the specifics were.
And during that discussion where you discussed charges, all three of you had your body camera off, is that correct?
Honestly, I'm not sure what we discussed after the camera was turned off.
Okay. Can't remember that part?
Sir?
You can't remember that part?
Correct.
Okay. You didn't write any reports in this case?
I did not.
Okay. No further questions.
Any redirect?
No redirect, Your Honor.
All right, let me step down. Does it need to be retained?
No, Your Honor.
Where you go? Thank you, sir.
Thank you.
I'm sorry. I know the defense had or the defense.
All right, does the state wish to have him retained?
The defense wishes to have him retained.
Okay, so if you're still under subpoena from the defense, you don't leave the courthouse. State, you may call your next witness.
The state rests our case in chief.
All right, ladies and gentlemen, so this is time and we're going to take a longer break, and it's the perfect time to take a lunch break. So it is 11:50 right now. Please be back at the courthouse at 1 o'clock, and we'll start as soon after that as possible. Please do not discuss anything you've heard so far. Do not look up anything related to the case, and please leave your notes on your chairs. And please meet the clerk where you met him this morning. And please leave your notes, sir. All right, you may be seated. All right, the state has rested their case. Defense, do you have a motion?
Yes, Your Honor. At this time, defense moves for a judgment of acquittal. In reviewing the evidence in the light most favorable to the non-moving party, the state has failed to present a prima facie case as to the offense of driving while license suspended or revoked. To prove the offense of driving while license suspended or revoked, the state must prove three elements. One, that Mr. Riley drove a motor vehicle upon a highway in the state. Two, at this time his license was suspended. And three, at that time Mr. Riley knew that his license was suspended. The state has failed to provide competent substantial evidence as to element 3. Florida statute 322.34 subsection 2 provides how the knowledge element may be satisfied. It reads, the element of knowledge is satisfied if the person has been previously cited as provided in subsection 1, or the person admits to knowledge of the cancellation, suspension, or revocation, or suspension or revocation equivalent status, or the person received notice as provided in subsection 4. There shall be a rebuttable presumption that the knowledge requirement is satisfied if a judgment or order as provided in subsection 4 appears in the department's records for any case except for one involving a suspension by the department for failure to pay a traffic fine or for financial responsibility violation. Additionally, 322.34 subsection 3 does provide that in a proceeding regarding a violation of the section, that the court may consider evidence other than those specified in subsection 2 that the person knowingly violated the section. The state has presented a certified driving record which shows Mr. Riley's driver's license was suspended on May 7, 2023. The record provides the basis for the suspension as personal injury protection, property damage liability, commonly just simplified and abbreviated as PIP. PIP is a financial responsibility violation, which was suspended pursuant 324.0221 within the chapter titled Financial Responsibility. Because Mr. Riley's license was suspended for a financial responsibility violation, there is no presumption of knowledge based on department records indicating a notice was sent. Mr. Riley never admitted to knowing his license was suspended. Rather, he told officers that he did not know. And the state did not present any evidence that he had previously been cited under 322.34. Therefore, the knowledge element is restricted to 322.34 subsection 3, which allows the court to consider other evidence. In this case, the state has presented testimony from Officer Oliver that the notice was sent to P.O. Box. However, she also admitted that she previously testified under oath that the notices were sent to 429 West Brevard. Those are exactly contradictory, Your Honor. They did not present any evidence in the matter from anyone who actually knows where the notices were sent. Further, the state has presented a current driving record. The record does not represent his driving record at the time, noted by the inclusion of suspensions in September of 2023, which was after this incident. Also, the driving record provided includes two addresses, a residential address and a mailing address, which are different. I'd like to present the court with two cases, Your Honor.
Okay.
May I approach?
Mr. May?
I have copies for the state. And may I approach?
Mr. May? Thank you.
First, I would like to direct your attention to Robinson v. State, 348 Southern 3rd, 1146, that filed the Florida 4th DCA in 2022. In Robinson v. State, the defendant was charged with driving while license suspended or revoked. The state presented evidence of a driving record from 2020, which included the suspension of issue from the case, which was from 2012. However, the 4th DCA held that the address on the 2020 record was insufficient to establish a last known address in 2012. The DCA held that it was improper for the trial court to deny defense's JOA on the matter. Now I'd like to direct your attention to Anderson v. State, 87 Southern 3rd, 774, from the Florida Supreme Court in 2012. In Anderson v. State, the Florida Supreme Court ruled that the state had established the element of knowledge to driving while license suspended or revoked when the state entered a driving record with a mailing address and the defendant testified to residing at that address at the time it was sent. Your Honor, while they have entered a current driving record, they have not presented a driving record that pertains to the address he had at the time of this incident. The officers have directly contradicted their own testimony about which address it went to. Additionally, he has never testified regarding that being his address. While they're saying that that's what he says is his address, if you look at the videos and you listen to it, he never says that 429 West Brevard is his address. He never tells them his address. So the state has failed to prove the knowledge element.
Okay. State, your response?
Judge, I don't necessarily, I'd have to take some more time to look at Anderson, but I don't necessarily believe that Anderson stands for that proposition. I don't deny what the counsel's saying, but if it does, it actually would say that it looks to be that when the defendant testified that he had received notice, that that was good enough. But looking at Robinson, I think if the court takes a look at the second page on the right-hand column towards the top, the court says, regarding notice, the state is required to prove that DHSMB mailed the notice to the last known mailing address. The next paragraph goes on to say, here, appellant denied having knowledge of the 2012 suspension and denied receiving notice of the suspension. That's obviously coming after this point in our case here. If the defendant were to get up and testify to that, that might be a different story on the defense's second motion at the closing of their case. But with regards to the notice that was sent, Judge, the state has entered into evidence a certified driving record from the Florida Department of Highway Safety and Motor Vehicles. On it lists two addresses, the 429 West Brevard Street, where the defendant stated to the officers he was going to, which was his residence, and a mailing address of P.O. Box 11184, Tallahassee, Florida 32302, which, shown by the close-up photo that the state entered into evidence, was one of the documents that the defendant handed Officer Oliver to prove what his address was when she first made contact to him. So regardless of what the officers believe notice was sent to, there is an argument to be made that both of these addresses are where the defendant would have received mailing, whether it went to the home or the P.O. box. And also, Judge, I remind the court that on page 2 of 7 of the driving record, it states that notices are mailed to the last address provided to the agency pursuant to 322.251, And in most cases, notice is mailed 20 days before the sanction begins. However, there may be certain exceptions, and it lists those exceptions. In either way, Judge, the state has proven with regards to DWLS that notice was mailed, notice was sent to at least one of the two addresses that are on file that the defendant stated was his or showed was his. So for that reason, Judge, I would ask that you deny the defendant's motion as it pertains to the DWLS charge.
Response, and Madam Clerk, can I see the driving record? I believe it's the first one.
So, Your Honor, you will see on that, which is a current driving record, that's not his driving record specifically from the day of this incident. Like I said, it has information post this incident. So it's not necessarily accurate to May 7th, 2023, which is what is pertinent in this issue. They list two addresses. They have a mailing address and a residential address. Both officers have given different testimony. Officer Oliver contradicted herself. She first was saying with absolute certainty that it was mailed to 429 West Brevard. And then she said with absolute certainty that it was mailed to the P.O. box with the numbers listed. And then Officer Muth, who also has no personal knowledge of this, is saying that it went somewhere. They have not presented any evidence, but anyone who actually knows where these documents went, if they went anywhere. And there being something that says that a notice was sent is insufficient.
Judge, I believe that's a misstatement of what counsel actually read in the statute in her first part of the argument.
Give me that statute one more time.
It's 322.34 sub 2, Judge.
3-4.
Sub 2.
Your Honor, it's actually subsection 3.
Subsection 3 is in any proceeding for a violation of this section, the court may consider evidence other than that specified in sub 2 that the person knowingly violated the section. Sub 2 actually states, and I believe it is after subsection 2C, the element of knowledge is satisfied if the person has been previously cited as providing subsection 1, or the person admits to the knowledge of cancellation, suspension, or revocation, or suspension or revocation equivalent status, or the person received notice as provided in subsection 4. And subsection 4 states any judgment or order rendered by a court or adjudicatory body or any uniform traffic citation that cancels, suspends, or revokes the person's driver's license or places the person under suspension or revocation equivalent status must contain a provision notifying the person that his or her driver's license has been canceled, suspended, or revoked of such suspension or revocation equivalent status. There shall be a rebuttable presumption, and this is back into subsection 2, there shall be a rebuttable presumption that the knowledge requirement is satisfied if the judgment or order as provided in subsection 4 appeared in the department's records for any case except in one involving a suspension by the department for failure to pay a traffic fine or for a financial responsibility violation.
Which is what we have here, Your Honor. It's a financial responsibility violation, so therefore there is no rebuttable presumption.
So you're saying not having insurance is a financial responsibility?
Yes, Your Honor. It's specifically a violation of statute 324.0221, and that's literally under the chapter titled Financial Responsibility.
I'm sorry, 324.
324.0221.
Yep, so it does show up as a financial responsibility for having your license suspended for not having PIP. So does that change the state's argument?
Just a moment, Your Honor.
State?
I'm sorry, just one moment, Your Honor. So, Your Honor, I would agree with counsel's argument. However, I would say that at least the state could have still proven under 32203 that as the lesser of the DWS, the defendant's license was not valid at the time. And therefore, we should still be able to go forward on at least that charge.
On a no valid driver's license charge?
Correct.
I'm going to grant the judgment of acquittal based on the statutory provisions and the fact that this was a suspension for a financial responsibility. I'll grant the JOA as to count 2.
Thank you, Your Honor.
So we take a break for lunch. Defense, do you want to do a colloquy now of the defendant?
First thing, just for clarification, has been brought down to a no valid driver's license or different?
It's JOA, the count's JOA.
Okay, thank you, Your Honor. Could we have the colloquy after lunch, please?
Sure.
Thank you.
So I believe I asked the jury to come back at 1 o'clock. If you guys want to come back at 12:50, that'll just give us a few minutes to do that, and we can talk about the rest of the afternoon.
Sounds good, thank you.
Okay? We'll be in recess.